So finally, welcome. I'm so excited to be here with you today. My name is Anna van Reebay, and I'm the founder of Ocean Vision Legal. Ocean Vision Legal is the first law firm worldwide that entirely specializes in marine protection. With that, we can already see it's quite a new branch, and it's also quite a new thing to actually really try to legally enforce these marine protection obligations. We entirely focus on the international law of the sea, which of course has interfaces with other laws such as human rights or climate change. Because, for example, when the sea level rises, which is a marine, like a sea issue, that also is very prone to harm some human rights for the people living at low-lying countries. Or ocean acidification is connected with climate change. We know that the ocean is one of the biggest carbon sinks. So all these branches are quite interrelated. So law of the sea and marine protection, therefore, is focused on law of the sea, but also has interbranches to other laws. What we do in Ocean Vision Legal is what I call ocean litigation. This is something quite new that does not yet exist like that, and that we are just starting in this time. What we are focusing on is to enforce the existing obligations of states to protect the marine environment. You already probably heard about the term climate litigation. So what we really want to do is to, similar to climate litigation, which was this kind of fresh wind going around the globe and really motivating people because they finally felt like we can do something, we can stand up, we don't want this to happen, we can actually sue a state. We were wondering, why don't we have that for the ocean yet? So what we are trying is to establish this term, ocean litigation, and really enforce these obligations. So looking at it from a legal perspective and the perspective of a lawyer or barrister, one of the biggest requirements, of course, that I have if I want to enforce an obligation is that there is a legally binding law. So what we need to look at quite quickly is what are actually the sources of public international law that are capable to bind a state. And there are three sources, according to Article 38 of the Statute of the International Court of Justice. The first source of public international law are treaties. So treaties or agreements or convention, it's all really the same. It's just different words. So you can use them interchangeably. Just if a treaty has a name, just use the name of the treaty. But it's the same if it's whether it's a treaty, agreement, or convention. The special thing about these treaties, though, is, and also the biggest impediment, is that they're only binding between the state parties. The second source of international law that we have is customary international law. Customary international law comes into being through customs. So when there is a consistent state practice, which is accepted as law. So a couple of states act in a certain way because they think they're obliged to do that, then this is actually able to create law. The special thing about that is that it can be binding for the whole state community, except for those states who persistently object. The last source are general principles, which are just general principles that are present in most of the national jurisdictions. But what is really important to note here is that a regulation at the same time can be a treaty regulation or a customary international law. Because, for example, there can be an old principle in law, which is already established in customary international law, and a later treaty just reflects this law. Or the other way around, a treaty can actually write down a law which is just in the development and as such contribute to the development of customary international law. So one regulation can be a treaty regulation and a customary law. The biggest convention, treaty, agreement that we have in the law of the sea is the 1982 United Nations Convention for the Law of the Sea. The UNCLOS has 168 parties at the moment, not all of them states. It's 164 state parties and then 4 other entities such as the EU. And almost about 30 non-member states. For example, the most prominent non-member is the USA. the reason for the USA not having adopted the UNCLOS, although being part of the negotiations, was the regulations on deep sea bed mining that they didn't want to be bound to. So, but what is really important to note here is that we have 168 state parties in the treaty. That does not mean that all regulations in the treaty do not bind those non-member states, because maybe they're also customary international law, so they bind the whole community. All right, looking into the development of the law of the sea actually also gives quite a few insights on how the sources developed, why we have this law now, and the challenges that we look into. So very briefly, a look into the development of the law of the sea shows that the law of the sea actually is one of the oldest fields in international law. It is very easy to trace it back even to times of when Columbus voyaged around the globe to discover the Americas, because in the aftermath, there was a treaty, the Treaty from Tordesillas in 1493, that delimited the Atlantic Ocean between Spain and Portugal. So the law of the sea is one of the oldest fields of international law. And although we sometimes have a treaty like the Treaty of Tordesillas, traditionally, it was only customary international law. So it just came into being because of the state practice of the countries who started voyaging around the globe and started acting in a certain way. That started creating the laws. One of the biggest issues in the law of the sea, traditionally and always, is, for this reason also, the designation of sovereign rights and the designation of zones in the sea. Because when states started exploring and discovering the world, they also wanted to know what part of the sea is theirs or not. So this question, whether we have an open sea or a closed sea and who does it belong to, is very old. The current prevailing principle, the freedom of the high seas, goes back to 1609 to Hugo Grotius. The two opposing principles was either that you could establish a closed sea in which no state had any sovereign rights, and except for where it was designated, or to the freedom of the high seas, what we have today, in which we say the whole high seas is completely free, except for where sovereign rights are attributed. So some of these principles that we still have in the UNCLOS today are very old. The first attempts to actually codify the law of the sea only started in the middle of the 20th century with the Law of the Sea conferences. So in 1958, there was the first time that we actually had 4 quite comprehensive instruments, treaties, to codify the law. And the focus of these treaties still very much was the distribution of sovereign rights in the sea, because that determines everything. That determines where you can exploit, and of course, where you can exploit resources, you can make lots of money. So the economic imperative is very much what is at hand here in the law of the sea, and especially in the traditional law of the sea. At the same time, though, in the 1950s, there were some major oil tanker accidents, and the pictures of those, of the seabirds covered in oil, and also this harmful effect of human activities and the marine environment became more visible. So the awareness only started rising then. The UNCLOS, though, was only adopted in 1982. It took almost 10 years of negotiations. They started in 1973 and adopted it in Montego Bay in 1982. Because it is such a big convention, and because you also have now an understanding that states have very diverging interests in the sea, because every state wants to purport to subject the biggest parts of it to their territory so that they have rights to exploit it. So it is really actually a masterpiece, and really special that it was able to adopt such a big comprehensive treaty. And it was unprecedented that on the day of its adoption, 190 states adopted the treaty right away. So it is quite a masterpiece and quite a big thing. The UNCLOS has 2 main functions. The first function still is the delimitation of zones in the sea. So it divides the sea into different zones and also attributes the sovereign rights of the states, what they can and cannot do in these zones. This is still, ever since, one of the biggest questions in the law of the sea because it touches the economic interests. However, because of also these oil tanker accidents and the growing awareness that actually human activities in the sea have quite a harmful effect, states started recognizing that the ocean needs to be protected, and then there needs to be a cooperation and management. So in the preamble, the state parties realize and recognize that the ocean is one ecosystem as a whole and needs to be managed as such. This is what we understand today as ocean governance. It pays tribute to the fact and to the awareness that the problems of the ocean are interrelated and they need to be considered as a whole. Because when we look at ocean currents, for example, the big garbage patches in the oceans, it is pollution that was carried through the currents all around the globe and then settles somewhere. Or fish travel, there are migratory fish that travel and enormous distance and like thousands of kilometers, or things like sea level warming and ocean acidification are all things that do not only affect one specific area in the ocean, but rather are distributed throughout the whole ocean. So what we really do need, and the growing awareness, is that we need to manage it and coordinate it as a whole. In order to understand that a little bit better, we need to have a little bit of an understanding about these jurisdictional zones in the sea. So this looks quite overwhelming though, right now, but I'm sure we will be able to understand it in a little bit. I do not know if you guys have a copy of the UNCLOS with you. If you do so, I very much encourage you to take it out and read in the UNCLOS, because it's so much easier to understand laws when you actually see them and have them written out in front of you. So, under UNCLOS, UNCLOS divides the ocean into basically generally 5 big zones. The first zone that we have is the territorial sea. It is, according to Article 2 UNCLOS, it starts at the baseline on the coast and reaches 12 nautical miles off the coast. Under Article 2 UNCLOS, states have full sovereignty in this area. So this area can be understood from the perspective of sovereign rights as a prolongation of the land. So you can really imagine the same sovereignty on land also applies to the territorial sea. So it's the strongest one. It's where the state is allowed to do most. The adjacent zone of the sea is called the exclusive economic zone. Under Article 55 UNCLOS, the exclusive economic zone is measured also from the baseline and can be established up to 200 nautical miles of the coast. Now, why I say it like this is because the EEZ, the exclusive economic zone, does not exist per se. It needs to be established. So if a state does not designate that, like write something, publishes, is okay, we are going to establish an exclusive economic zone and it's going to reach 200 nautical miles, it doesn't exist. The 200 nautical miles here is the outer limit, so it cannot be longer. And so we already jumped to the next zone. The zone adjacent to this 200 nautical miles, like the zone adjacent to the territorial sea or to the exclusive economic zone where it has been established, is the high seas. The high seas is a freedom, is an area that is completely, that cannot be subjected to the sovereignty of a state. This is one of the guiding principles, and as we already learned before, although this is a treaty regulation in UNCLOS Article 89 and 87, this is actually a customary international law that has long existed before that. So traditionally, no part of the high sea can be purported to subject to the sovereignty of any state. Important to note that this refers to this territorial sovereignty. So no state may go out there and just like, drive out their ship there and be like, okay, I'll establish a little piece of France here now, or England, or whatever part, New Zealand. That is not allowed. However, the high seas is not an area without law. There are still laws that govern this area, which we can see because Part 7 of UNCLOS, which starts with Article 86, contains a lot of regulations that are applicable for the high seas. For example, regulations on fishing or shipping and navigation. So while no state is allowed to subject any part of it to their sovereignty, there are still laws that govern this area. All right, we now looked at the areas in here, which are the areas under national jurisdiction, because states can either have full sovereignty or can have single sovereign rights. I think I did not elaborate on that. Just to catch up on that, the EEZ generally is a zone free. So the general principle of the EEZ is the same as the high seas. The EEZ are free, but the state has single sovereign rights. It was established because actually states found out that there are quite a few resources out here, and they don't want to just cut off their rights to exploit the resources here at the territorial sea. So in the UNCLOS, the only way that they could actually agree on these zones was that they give the zone in the middle, in which is actually free, but the states are still have the right to exploit it. Because this area has single sovereign rights, we also call it an area under national jurisdiction, whereas everything beyond either the territorial sea or where established the EEZ are areas beyond national jurisdiction. The zones that we talked about right now are the water columns. The UNCLOS also divides the sea floor. The first part is the continental shelf, according to Article 76 UNCLOS, which either reaches 200 nautical miles off the baselines, or where it is longer, where actually the continental margin is longer to the extent of that. That's then called the prolonged or extended continental shelf. This is an area in which the states have single sovereign rights, and it starts after the 12 nautical miles. Everything beyond that is what we call the area. It is regulated in Article 1, Paragraph 1 UNCLOS, and it's mainly governed by the ISA. Now, why do I show you this when we talk about ocean governance? Because when we look at all these zones of the sea and these borders that some humans just decided, oh, let's draw a border here, 200 nautical miles, and just, that's the border, or 12 nautical miles, that's the border. Well, fish do not obey those borders, and ocean currents don't either, and the ocean ecosystem don't either. So what we can really see is that actually a unified ocean governance can be very much impeded by these jurisdictional zones of the sea, because here they're all different jurisdictional rights. And if we want to manage the ocean according to how it is needed and according to the ecosystems, there can be quite a clash. What's more, and I heard that you already learned a little bit about that, the current legal system for the ocean poses many gaps and overlaps. This is because the treaties in the law of the sea that govern ocean spaces have developed thematically. So, for example, in the area of whaling, the International Whaling Commission started, and they established the International Whaling Convention. Then what we also have is a lot of regional fisheries management organizations with their conventions. We have the IMO, the International Maritime Organization, that adopts laws on shipping, or that has a mandate for shipping. We have the Convention on Biological Diversity that you learned about today. We have regional seas like the Antarctic, or the Arctic Sea, or the Mediterranean Sea. There is the Food and Agricultural Organization with a mandate to regulate things on food. So what we see, even like on top of this, on this fragmentation because of this jurisdictional zones, we also have a big fragmentation in the law of the sea because there is a multitude, in fact, a multitude of regulations and conventions that apply to different topics, but that are not unified. So there are significant gaps and overlaps in here. In fact, more than 1,000 treaties exist that govern international environmental law, of which more than 300 are connected to the law of the sea. So this is just, there's a lot out there, and what we really need is a process to unify all these instruments out there and in order to provide a harmonized management. And this process, or this need for unification and this wanting to do that, is what we understand today as ocean governance. So it's important to note that it's ocean governance and not ocean government, because in international law, we do not have a mandated authority like a government that is competent to adopt legally binding laws for all states. So while it is not ocean government, ocean governance connotes to a process of close cooperation and coordination between the states and other actors in order to structure the use of the sea space. It can cover treaties, policies, concepts, formal and informal rules. So it really addresses all of these regulations and instruments that are out there. Some of the instruments that are frequently used in order to apply this ocean governance are, for example, environmental impact assessments, especially when on a large scale, or area-based management tools such as marine protected areas. So what we have in ocean governance, or what it provides, it's actually a shift from the sovereign rights perspective to a more integrated ocean management. Well, that sounds quite good to start with. However, there is one enormous problem with that. Because as I already said, there is no mandated government to adopt legally binding laws. These concepts are concepts and not legally binding. So we have that's what actually makes whole international public law and law of the sea also specifically frequently being called a truthless tiger, because you have these ideas and you have these, you want to manage it, and you have some informal rules to do it, and lots of scientists agree that these are really the tools that could help. However, then they're not legally binding and states just do not obey. This is where we come into play, because this notion is not shared by me or by my law firm. And so I wrote my doctorate thesis actually on the obligation of states to protect and preserve the marine environment, because I think from a legal perspective, there are legally binding laws, and we already looked into it because of the UNCLOS. UNCLOS, also called the Constitution of the Ocean, because it is the biggest and most comprehensive treaty that we have for the law of the sea. And quite amazingly, UNCLOS has a whole part 12, which is completely dedicated to the protection and preservation of the marine environment. And its starting article, the first article in part 12, is Article 192 UNCLOS, and it reads, "States are obliged to protect and preserve the marine environment." Yes, this is my favorite article, because actually with everything that we said before, and it's not legally binding, and what do we do about it, always makes it so untangible. And what we really need to do from a legal perspective is we need to support that with a legally binding obligation. And why I get so excited about this article is because Article 192, after my investigations and also really reflected in a lot of the literature and also jurisprudence by now, is an obligation which is legally binding. So states are obliged to protect and preserve the marine environment. What it shows, it addresses states. So because it is an UNCLOS regulation, it is regulated in the treaty. This is legally binding, and it is legally binding for all states. And now, most fascinatingly, we need to draw upon what we established before. UNCLOS is only, I mean, that's a lot, but adopted by 168 parties. So there are still almost 30 states who have not adopted UNCLOS. However, an investigation of Article 192 UNCLOS showed that it, on the same time as a treaty regulation, is also a customary international law, and there are no persistent objectors to that. So fascinatingly, Article 192, the obligations of state to protect and preserve the marine environment, is a universally binding obligation. It binds every state out there, coastal state or landlocked. Secondly, because Article 192 is not regulated in one of the parts on the jurisdictional zones, like Article 1 for the territorial sea or the EEZ or the high seas, but in its very own Part 12, it shows that it is applicable to all of these zones and not just in one of the zones. So it applies and is legally binding in all zones of the sea, irrespective of the jurisdictional rights. And lastly, Article 192 is not specified to a specific activity, so it is legally binding for all activities that happen out there in the sea. So this is actually the law that we have that is capable to unify all these treaties out there, to unify this obligation to protect and preserve the marine environment in all zones of the sea. Well, that would be great. And if it would be that simple, like, you know, why don't we have a better protection system out there? Why are states still whaling? Why are states still using bottom trawlers? Like, if that is legally binding. The problem is that there is no enforcement. We have amazing laws in the law of the sea with UNCLOS. However, states are not enforcing them yet. And this is something I want you to keep in mind also when you have your lectures in the afternoon on the BBNJ. It is nice and great that states are trying and are adopting new laws. I'm a great fan of new laws because with the development of society, we also need new laws, obviously. However, we actually do already have amazing and legally binding laws, but if states are not starting to enforce those, we can adopt as many treaties as we want and they will not have any effect. So actually, in my humble perspective, I think we don't even, like, UNCLOS is so comprehensive and it provides for so many obligations. The only thing that we need is to enforce it. And the enforcement of such is what we call ocean litigation. In the law of the sea, states have a choice when they want to bring a lawsuit. They can bring it to two courts, either the International Court of Justice, the ICJ, or to the specialized court for the law of the sea, because there's actually even a whole own tribunal that is competent for law of the sea matters. It's called the International Tribunal for the Law of the Sea, and is seated in Hamburg, where I'm not from Hamburg, but from Germany. So it's seated in Germany. Surprisingly, in its many years of existence, it was established in 1996, UNCLOS only had 32 cases. And let's be frank, that's not a lot. That's like one case a year, something about that. So what's the problem? Well, in international law governs the relationship between states. For this reason, only states have a legal standing in court. So I, as a private person, cannot go to UNCLOS and say, like, UNCLOS, I want to sue all these states who still conduct bottom trawling, so I'm going to sue them now. I cannot. Only a state can do that. However, states are very reluctant to sue another state because it threatens all their political relationships. And in real life, states don't just really think that marine protection is important enough to go out there and completely threaten all their political relationships by suing another state. This happens very rarely. So most of the cases that UNCLOS had was something on prompt release of vessels because one state detained a vessel from another state. That affects their economic interests. That's important, then you sue. But for marine protection, reluctant. Nonetheless, I'm very inspired because there are actually two ways to address the UNCLOS. You can bring a contentious case to UNCLOS. This is when you sue another state. Or you can ask the UNCLOS for an advisory opinion. Advisory opinions are quite interesting, and there's quite an upswing of advisory opinions noticeable in this current era. What is an advisory opinion? An advisory opinion is an advisory opinion given by the court, given by UNCLOS. ICJ can also give advisory opinions, but in this case from UNCLOS, on the interpretation of law. So one state can actually work together with another state. It needs at least two states, two or more states can cooperate together and frame a legal question and go to UNCLOS and say, hey, UNCLOS, there's a regulation in the law of the sea. It is quite unclear. We have a legal question on it. Can you please clarify? So a state can ask the court, the tribunal, a legal question, and then the tribunal gives its answer. Well, why do I find that so fascinating? Well, because of the effect of AOs. First and foremost, I need to mention, advisory opinions are not legally binding. Why? Because there is no state that sues another state, so between whom would it be binding? It's just an interpretation of the law by the court, so it cannot be legally binding. However, and this is really important to note, if the highest court or tribunal in international law or the law of the sea gives an interpretation of what it thinks is lawful and what is unlawful, this has enormous authoritative effect because it's the highest court, and the highest court says, okay, we think that's legal and that's not legal. So it does have actually quite an effect. Also, it can be a precedence for future lawsuits. For example, then later, a state may be much more inclined to sue another state because they already know what the outcome, what the judgment will be, because the tribunal already gave its interpretation for the law. So the risk of losing a case is much reduced. And lastly, we've touched upon customary international law, which comes into practice, which comes into being through a state practice that is acknowledged as law. So if the tribunal acknowledges something as law, this can have an enormous contribution to the development of customary international law, and with it to a new law itself. So why advisory opinions in such are not legally binding, they can have an enormous effect. The UNCLOS in its past has had 3 advisory opinions. The most recently was posted to it last December 2022 by the Commission of Small Island States, and it was on the obligation of states under Article 192 UNCLOS with regards to climate change. So it asked the tribunal, what are the obligations of states to protect and preserve the marine environment in connection with climate change? And what is quite amazing and unprecedented, the tribunal, only 10 months after it received this request, already scheduled the oral hearings, which will start this September 11th for 2 weeks. What can we see with that? Well, there's an enormous readiness of UNCLOS to accept these cases. I want to go into that a little bit further here. So when we have an outlook and when we look at this, what's the current state of the law of the sea? We looked at the past, we looked at development, and when we look at it now, like what's going to happen in this next decade, which is the United Nations Ocean Decade. So what's going to happen with the law of the sea then in the 21st century and in this UN Ocean Decade? Well, the UNCLOS has a fundamental role to develop the law. And with accepting the advisory opinion, it can actually contribute to this role, because it can contribute to the development of law. And it has done so in the past. For example, what we already touched upon, the prompt release of vessels when one state detained another state. Through the jurisprudence of UNCLOS, we now exactly know the penalties to do that, for how long, how much, and exactly there are whole tables that you can look into it. And these tables are not in UNCLOS, but there are laws in UNCLOS, and then through the jurisprudence of UNCLOS, it has developed a subtle case law in which we now exactly know what to do and what happens when one state detains a vessel of another state. When we look at UNCLOS and this role to develop the law, it is so fundamentally important, because UNCLOS was adopted in 1982. So if UNCLOS is to remain its purpose and functions, we need to interpret its obligations. New challenges, such as new technologies or developments in the society, also needs an adaptation in law, otherwise it's not relevant anymore. So when we look at the UNCLOS regulations, which is called the Constitution of the Ocean, its articles may be quite general, like the Article 192, but that gives space and gives UNCLOS the opportunity to actually develop it through its jurisprudence, and so that it can remain relevant also with the development of new technologies. And the UNCLOS shows very much its readiness to do so, because with scheduling this oral hearing for a matter on marine protection within just 10 months, and this really is unprecedented. It usually takes 2 years. It shows that it's ready to adopt its role, to cater to its role, to develop the law of the sea, and also that it wants to develop other branches in the law of the sea other than prompt release of vessels. It is also ready to define and redefine the obligation to protect and preserve the marine environment, and give a precise interpretation what that means with specific cases, for example, in connection with climate change. So from my perspective, we really see that UNCLOS is opening up, is accepting its role, wants to invite cases, and is ready to do so. With UNCLOS, we already just said that UNCLOS has actually regulations that are so general that they are possible to develop, because the fathers of the UNCLOS, like the negotiators in the years from 1973 to 1982, they already knew, wow, that's quite a long time. So we really need to frame the UNCLOS in a way that it is a living instrument. That's the living tree doctrine. So they really intended for the regulations to be framed in a way that they can develop over the time of law, so that UNCLOS does not get irrelevant after just a decade or so. So as you see, it was shaped in a way to be open for interpretation. And what I see right now in this year and in the past years, even more, is also a readiness of states to start developing the obligation to protect and preserve the marine environment. So what we call ocean litigation. Because what we can see, one of the advisory opinions that has been handed in is the COSIS, the advisory opinion, the Commission of Small Island States on the obligation under Article 192 in climate change. However, this is just one of 3 advisory opinions within 1 year on this obligation, on the obligation of states for marine protection and environmental protection and climate change. There is another advisory opinion from Vanuatu addressed to the International Court of Justice on climate change, and a third advisory opinion submitted by Chile and Colombia to the Inter-American Court of Human Rights on the scope of states' obligations for responding to the climate emergency. So what we see and what my outlook to this UN Ocean Decade is that there is a readiness of the courts to accept the jurisprudence and to develop the law with regards to marine protection. UNCLOS provides for that. We have the legal basis for that, and states are starting to waking up to enforce this on the subtle way to use advisory opinions, which can be the pavement for later contentious cases, and which also contribute to the development of very strong marine protection obligations. So from my perspective, I'm quite excited about this decade, and I can also spill as much as that I'm saying my law firm itself is already working on 2 advisory opinions, one to UNCLOS, one also to the Inter-American Court of Human Rights, both connected to the protection of the marine environment. So this was quite a lot, and we've touched upon many topics. I've added a recommended reading list for you in case you want to go into specific topics. The law of the sea in general, the obligation to protect the marine environment is where I wrote my PhD on, or advisory opinions specifically. And I really want to thank you for your attention, for sharing this passion in marine conservation. Please do get in touch if you have any questions or if you want to discuss any topic further. I'm providing my contact details here, and I would be very honored to discuss further with you. And right now, I'm very excited to give the floor back to you guys, and I hope that you took some notes or if you have some questions, and to go deeper into the questions that popped up or some topic that you want to delve into deeper. So thank you very much.